Good evening and welcome to Bexley Public Library. My name's Leah Boyden. I'm the Community Outreach Librarian, and tonight we're joined by Lauren Bowen. Before I pass the mic off to her, a couple of announcements. We're joined by folks online as well, so welcome. Thanks for joining us online and in person. We are going to have a question and answer session at the end, but we are going to pause the live stream just to protect any personal questions, personal information folks want to ask. So if you are online and you have a question for Lauren, we have put her email in the chat. So her email is there. There's also a link to a handout, which you have at your seats here. And any follow-up questions, contact information, we will make sure to send. So you have Lauren's information. A couple of other housekeeping things. The library does close at 8. So for those of you in person, if we do go past 8, I'll just ask that you exit the auditorium doors. If you need the elevator, find me and we'll get you out that way. And I think those are all of the housekeeping things. Lauren is going to talk into the mic for those online so we can have that good sound. And I'll turn it over to Lauren. Thank you so much.
Thank you, Leah. The other note I wanted to add about questions, if you have them during the presentation and you're watching online, you can put them in the comments, and there are a couple natural pausing places in the presentation, and we might be able to answer them. Just please, if you're asking questions in the room or online, try to avoid asking me very personal or very specific questions about your own children. Try to keep them general. I always tell people I don't know what I don't know, and what I don't know is a heck of a lot. So I'm here to help with the concepts we're talking about tonight and general Ask an Advocate questions. But if you have very specific questions, please send me an email and I'll try my best to help you in a way that is efficient and also protects your privacy. Okay, we're gonna get started. I'm Lauren Bowen. I'm a special education advocate. I live in Bexley. I have 3 children. I have one child on an IEP and one on a 504 plan, or as she calls it, her terms of service. And I have been in the advocacy space for a really long time. I like to tell people my first client was my sister. She has a heart condition, and we were struggling to get her accommodations on the presidential fitness test in high school. So I've been doing this for a while. I spend a lot of my time trying to build teams, build successful school teams, and then I spend a significant portion of my time volunteering as an educational surrogate parent for students that are in foster care. That's a little bit about me and where I'm coming from. I am hopeful that I can present some of this to you in parent accessible language. I am just a mom. I just happen to know a lot about this one thing. And this one thing can be complicated, but I am also here to tell you you don't have to know everything in order to advocate successfully. If you thought that I would start this presentation by telling you that special education law is simple, I have terrible news for you. It's not, but with a little bit of community building, team building, trusting your school team, trusting yourself as the expert on your child, I do think that we can build successful teams and we can hopefully improve our children's educational experiences across the spectrum. That is my kind of why. I will always tell clients, first thing, I believe in the mission of public education, and I believe in the right of public education for all students of all kinds, all students of all brains, and that's why I do what I do. So with that, I'm gonna get into it a little bit, and since we have kind of a small crowd, if you have a general question, please feel free to stop me. If I talk too fast, please feel free to stop me. I also talk with my hands a lot, so if I'm waving the microphone wildly and you've completely lost me, Leah, give me a signal of some kind.
And if you have a question as we go, if you could wave me down so I can bring you the mic so folks online can hear it, that would be great.
Okay, first slide is really general, something I just want you to be thinking about as the presentation goes. I usually do an Ask an Advocate once a month or so over Zoom on my website. Any and all are welcome. Sometimes it's been 2 people, and we had a really interesting conversation about cookie recipes before Christmas, and once it was 40 people, and I didn't get to all the questions. So please watch my website for upcoming events. If there's a topic you want me to cover or something that's really difficult for you and something you've been struggling with, I am 100% open to hearing it, and I love to talk, so I would love to have those discussions. Okay. What we're going to cover tonight, what procedural safeguards are and why they matter, your key parent rights under IDEA. The IDEA is the law that governs special education. You have a reference guide in front of you that when I start talking in acronyms should help, but please raise your hand and stop me if I get to something that you don't understand. Yeah, and I'm totally fine, Leah, if you want to, I gave you a link to the slide presentation. The question was, are you okay if they take pictures of the slides? The answer is absolutely, but it's fine, Leah, if you want to post the slides online. Okay, cool. And I talked over my own notes, so just give me 1 second. All right, we're talking about process here, like, we're not talking about blaming schools. I want to make that super clear. And I said it in my introduction, I believe in the mission of public education. I believe in supporting educators. So what I'm always going to seek to be doing is building teams, educating parents, and then empowering you to use this knowledge to have a more successful school experience. I tell clients I'm not a bulldog, like, look at me. So I am going to try to avoid conflict and argument as much as possible and seek to negotiate and be productive. We are going to talk about dispute resolution tonight because that's one of our procedural safeguards. And I want you to know that those are processes that are allowed to us under the law. Those are rights we have as parents. They are tools we can use. I often refer to them in meetings as bringing in another set of eyes. So in the end, it's not about, for me, anger and resentment. I always want to bring in the experts, use the law, and hopefully build a better team for everybody. But I want to acknowledge, like, everybody might be here, everybody might be listening that might have a specific struggle or an issue that they're facing right now. And I want to say that I understand and that I get that this is the toughest thing you'll ever do. Like, parents of kids with special needs are struggling. I think our educators are aware of that. Our fellow parents are aware of that. And I want us to try to work on this stuff together. Okay, so my quick thing, maybe I shouldn't have. All right, what do you know about special education? I struggle sometimes when I talk to people with what my audience knows. There is nothing simple about the IDEA. There is nothing simple about these processes. They are not written in parent-friendly language. So if you don't know an acronym, please refer to your handout. Confusion is part of the system design. Like, we're all going to be confused by this. So I always encourage people to reach out and utilize their community resources, ask their teachers, and ask their friends. And then please, again, ask questions so that others benefit from the answers. That's kind of my go-to. Ask the question out loud, don't be embarrassed, because others will benefit from the answer. Okay, I also included some resources there. Social media is super helpful and can be really validating, but social media is not legal advice, and I just want to put that out there. There's a lot of really good information out there. There's also a lot of really bad information, so please know your sources and, again, ask questions. Okay, this is kind of the meat of why we're here. What are procedural safeguards? Procedural safeguards are the rights we have as parents under the IDEA, which is the law that governs special education. Procedural safeguards are meant to be guardrails. They're not fancy loopholes. They're meant to protect us. They're meant to protect the processes. They exist because despite our best efforts, the power is uneven from the federal processes that hamper local school districts to state regulations that make it harder to get funding. The procedural safeguards exist so that parents have a place to go when something isn't working. They are designed to protect both student rights and parent participation, and they are there to ensure a free, appropriate public education, which is what all of our children are entitled to under the IDEA. And now I think we're going to go through some key rights. So we have some really definitive rights under the law. Parent participation is the first one I go to. You are the most valuable member of your student's team. You are a required team member. You are the expert in your kid, and that matters. It means that we can participate meaningfully in spaces where we feel like the teachers or the educators, the admin might have all the power, right? I always want to tell parents, you have so much more in your head than you know about your kid. Like, the teachers see your kid for hours a day, but like, you see the fallout and the exhaustion and the homework and the lack of understanding and the mental health issues. You're the expert in your child, and data that you bring to the school must be meaningfully considered. I always tell parents, like, in an IEP meeting, if you have one coming up, take a month and keep a journal. And if you've got a kid coming home and like, he's got math homework in front of him and he's like, Mom, I don't understand it. Like, I can't do it. I don't remember the directions. And you've got like a 3-hour meltdown over one math worksheet. Write that down. Give me the date, give me the time, give me how long it took, and then take that to the IEP meeting. That data is parent data and must be meaningfully considered in a meeting. And then one of the things I did as we go through like our key rights under the IDEA, I wrote in violation examples or like red flags, things you should look for. So if we're talking about a violation of our right to parent participation, we could be talking about placement decided without parent input. There's a couple issues there, actually. One is least restrictive environment, potentially. Meetings held without parents or attempts to include parents not documented. You are a required member of the IEP team, and you need to be at the meeting. And if you're not at the meeting and there was not documented attempts to contact you, then that is a procedural violation, and that would be an instance in where we would consider filing a state complaint, which is something we'll talk about later. This is a really important one, and I could probably talk about just this all night. So if you have any questions about it further, we can kind of dig in. But please remember, you're the expert in your child, and your voice should be heard. And if your voice isn't being heard, we need to have a serious discussion with the team about functioning appropriately. Okay, key right. Prior written notice. This one is confusing because it says prior written notice, but it comes after the meeting. This is Form PR01 in the state of Ohio. It is required before changes to identification, evaluation, placement, or services, and it must explain what is proposed or refused and why. Basically, I always tell parents, before any decision is made about your child, you must have notice, And if you make a request of the IEP team, it must be documented, their response must be documented, and their reasons why or why not they are choosing to implement the request must also be documented. The prior written notice is your record of the meeting. I like to think of the PR1 as accountability in writing. If it can't be explained in writing, it is probably not defensible, right? Like if we ask in a meeting for a student to receive 15 more minutes of reading intervention per session because we're seeing a lack of progress, we have a procedure where we need to document whether or not we're going to do that as a team. The prior written notice will be our record of that ask and the record of their response. So what you would want to see on the document is the team had a discussion about whether or not my student should have 15 more minutes of reading intervention per session. The team agreed or the team disagreed. Here are the reasons why or why not. The reason is not just the team doesn't have time. The reason isn't we don't think he needs it. The legal standard is cogent and responsive reasoning, which means data, explanation, assessment, something to back up why or why not they're choosing to implement what you're asking for. And it also must be written in parent-friendly language. So if you don't understand it, please, respond to it. Usually these things will come in an email with an attachment. If you don't understand what it says, ask the team to explain it to you. If you don't understand, ask. Okay, she has a question. If you don't understand the data that they're using to make the decision, ask them to break it down for you. This is when I say, you don't have to know everything to start, but you do need to know that you can ask questions. Okay. She's like, I don't need it, Mike.
If English is not the family's first language, are the schools required to provide this documentation in a language that they can understand, or is the onus on the family to get somebody to interpret it for them?
Nope, the school has to provide it in a language they can understand. Parent-friendly, parent-understandable language means language they can understand. It means they must work to provide notices and a copy of your procedural rights in your native language. So the responsibility is on the school there. Obviously, if the family is aware of an interpreter or somebody that could help, especially if it's a language that we don't encounter as much, that's helpful, but it is the responsibility of the school. It's an access issue. I think that was, okay, so violation example in this case would be services written or removed with no written notice. You notice that your student is no longer getting speech, and speech is on their IEP, and there was no notice and no data that says why this student no longer has speech. That's a violation example in this case. What did I do? There's the clicker. Okay. Okay, key right access to educational records. I'm not going to spend too much time on this because I think I could do a whole session on this, but please know that you do have the right to view records without unnecessary delay. This includes everything related to evaluations, data, emails. Service logs is the thing I was going to take off of there, actually, and then totally forgot. So you don't necessarily have the right to service logs or minute logs. You do have the right to assess progress and how progress is being measured and tracked, and part of that may be minute logs. I go back and forth on whether or not I want to talk about this one to families because there's some conflicting and sticky case law about whether or not minute logs are allowable. And I didn't want to get too into the weeds. But suffice it to say, you do have the right to review your students' educational records. Schools must provide that without unnecessary delay. They may charge you a reasonable fee to make copies, but a lot of districts just use a software program where it's really easy to go through and click and then download it all as a PDF and then send it to you. So you can ask, I need the last 3 years of IEPs and progress reports, and I need the evaluation, and they can go click, 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 and then give it to you. It should be a fairly conflict-free process. Records matter. Records matter to the district as well. They want to keep good data so that what they're doing makes sense and makes sense to you in case of a dispute. So it should be a fairly conflict-free process. I do think in a future session I'm going to cover the Freedom of Information Act as it relates to educational records, and then the FERPA, which is the Educational Records and Privacy Act. And so I think we could get into the weeds there, but for now, if anybody has any questions about that moving forward, I'm happy to answer them. And I'm not going to spend too much time on that slide because I think my favorite one is coming up. Come on. Okay, no, not my favorite one. It's the next one. These are more rights before we get to disputes coming up. The next right is your right to an independent educational evaluation, or an IEE. You can request an evaluation once per district evaluation when you disagree with the results or the decisions made using the results. The example would be the removal of services or the removal of eligibility, or the lack of eligibility if the decision is that the student was not eligible. If the district does an evaluation, you are allowed to ask for an independent educational evaluation. The law says evaluation at public expense, which means the district then pays for an evaluation with an outside provider. The provider can be recommended by the school district. Districts keep lists of providers so it's easier for parents to find them, but you do not have to use a provider that's recommended by the school district. Parents may request an independent evaluation at any time. The district has 2 things they can do once you request an independent educational evaluation. You get an ETR and it just doesn't sound like your kid, or you disagree with the decision that comes from the ETR, or you worry in the case of a student maybe not having English as a first language, you worry that it was maybe not conducted in culturally appropriate ways. You are allowed to disagree with the results and then request an IEE. The school has to do 2 things. The school can either do one of 2 things. They can fund the IEE, so at public expense, they can pay for it, or they can file for due process. And we'll talk about what due process is. It's an administrative hearing a little bit later in terms of the dispute resolution. But what the district would do in that case would be to file for an administrative hearing to defend that their evaluation was appropriate. So those are your 2 options. Whether or not the district chooses to fund or file, they must immediately provide you with district criteria for obtaining an IEE. So requirements about who does the evaluation in terms of their credentials, that's a reasonable criteria, and districts are absolutely allowed to impose that. They may also impose geographical limits. Within 60 miles is fairly standard. They may also impose cost criteria, and this is where there's a lot of case law and a lot of guidance that's come down from the Department of Education. Generally, cost criteria on independent evaluations is limited to unreasonable costs. So say we can get a full psychoeducational evaluation in 4 places in Central Ohio for $1,000. That is not even close to what it actually costs, but for the sake of simplicity here, if we can get it at 4 places for $1,000, and then there's somebody also in Central Ohio who's doing the same evaluation for $5,000, the district absolutely has a right to say, no, you may not go to the $5,000 evaluator. That is an unreasonable cost. They also must permit you to argue special circumstances. So if the difference between the 4 $1,000 evaluators and the $5,000 evaluator is that the $5,000 evaluator happens to have very specific experience with your child's complex medical condition, the district must permit that you argue that your child has special circumstances that would warrant the more expensive evaluation. And they, again, at that point are allowed to say, we must try this first. But their ultimate option is they either fund the entire thing or they file due process to defend the results of their own evaluation. We will talk about what due process is in a little while. The other thing I want to cover about IEEs really quick is that districts, if they choose to file due process, the law says that they must do so without unreasonable delay. However, case law, so cases that have gone all the way up to federal courts regarding what an unnecessary delay is, it goes anywhere from 3 weeks to 6.5 months. I think I read one that was decided in the district's favor at 9 months once. So the way that I see this as an advocate and the way that I try to approach this is telling parents that it is best if we let the district know that we know what our rights are in this situation. It's efficient for everybody. So when we request an IEE, we say, I'm requesting an IEE because I disagree with the results of the evaluation that the district conducted at this time on my child in this grade. Give them all the information. And then you say, following the IEE, I am looking forward to meeting with the district to meaningfully considering the results and then utilizing them as we make any decisions about FAPE for my child. So let the district know that you know what the procedure is here, and it will usually trigger them to okay, right, I have to send the email letter, or I have to send the protocol. I need to give them our procedures. And it usually lets them know, to make a decision right away. I give districts a week before I follow up on that request, and then I will politely poke somebody again. And I think I can think of only one instance that they have not responded accordingly. Usually, they have to call the school psychologist and they have to say, tell me about this student, tell me about this evaluation. And I think that I'm trying to be, sorry, totally lost my train of thought. I think that the most important thing here, this is a complicated procedure, and to let the district know, I know what I'm supposed to be doing, helps this be not an adversarial process. It's not about proving the district wrong. I think this is what I wanted to say and I just lost. Asking for an independent evaluation is not about proving one person or one team wrong. It's about bringing in an independent set of eyes and gathering more data, maybe being able to test with tools that aren't available to the district. I've had many IEEs look exactly or very similar to the school's ETR. Say the same things. This kid has this. This kid has this struggle. But sometimes in IEEs, what we've gotten is a deeper dive on one specific area. This kid has reading fluency issues that a school psychologist didn't miss, but maybe gave us some more information on. Maybe dug a little deeper. Maybe was able to get a kid to work a little harder because you weren't pulling him in the middle of a school day. Like the dispute resolution process and like the state complaint process that we'll get to in a couple minutes, I think for me, it's just about bringing in another set of eyes and bringing in another expert. And our school psychologists and our teachers and our admins are as overloaded as we are. So maybe giving us all a second to breathe and take a step back is sometimes super helpful. Okay, so with that said, I'm about to switch into dispute resolution mode. Does anybody have any questions about key rights that we've talked about so far? Okay, there are a couple. Leah's coming with the...
Hi, thank you. If we are asking for an IEE, do we have to disagree with something in particular, or can the reason we're asking for it just be because you want a second opinion?
So I would advise that we not use these tools without really considering like what we were after and what our goal is. It's not that you have to disagree with one specific test. The law actually provides that you don't have to let the district know why you're requesting the evaluation. You're certainly welcome to share that information with them, but you are not legally required to. A lot of times I try to think about it in terms of if you and the decisions that result from that evaluation are not, like, they don't make sense to you, if the IEP that comes out of that ETR doesn't look like your kid or serve your kid because we're missing something, like, that's a disagreement that I think would warrant a second opinion. If they say this child is no longer eligible for services, but you see them struggling, again, a disagreement that would warrant a second opinion. But I definitely advise judicious use of the tools that we have available to us. And I also think that sometimes we can over-test our kids. I mean, I've had clients where I'm like, yes, technically we could get an IEE here, but this is a kid who's been tested a lot, you know? And so at that point, as an advocate, I would come in and try to find and explore maybe other avenues, but it's available to us. You know, in the law says we need to reevaluate every 3 years. Case law says we can ask for an IEE up until about 18 months following that evaluation period. So you have some time to think about whether or not you maybe need a second opinion. Does that answer your question? Okay.
Are you required to permit the district to reevaluate your child either in relation to a request that is for an IEE or in light of the results from an IEE?
There's no provision in the IDEA for a district to cure its evaluation. So a couple of points to that, and hopefully that will answer your question. One is a district may not reevaluate within the same year unless all parties agree. That includes a parent. The other is that there's nothing in the IDEA that says that once a district has evaluated and a parent disagrees, that they have the chance to go back and fix the evaluation. I have certainly, with the agreement of parents, allowed a district to maybe go in and evaluate in an area that they had not previously, and in an area that I had requested an IE. In the case I'm thinking of, it was speech specifically. And some new data had come to light that said that maybe we need to take a look at this kiddo from a speech and language perspective, and the district had not originally evaluated for speech, and so we asked for a speech independent educational evaluation, and the district asked if they could, and if we would be willing to allow their district speech language pathologist to come in and do an evaluation, and that they agreed that the parent did not forfeit their right to an IEE by doing so. And then the district SLP came in and did the evaluation and did find some need for services in that particular case. Does that answer your question?
Are you asking if a district needs your permission to do the 3-year re-eval?
Well, they do. I know they do. No, I'm saying, assume they do an evaluation, assume you're requesting an IEE, possibly in relation to something specific. What are their rights in light of that, looking toward sort of, I guess what I'm saying is, like, can they defensively, can they defensively ask to evaluate because they want to get data from their own person in order to argue against whatever finding that that person may have due to maybe their expertise or whatever?
So you're talking about, like, if you disagree with the ETR?
No.
I think, so you have to have parental consent for any evaluation. So I think, without getting too specific, I think you'd have to have you'd have to sign consent for any specific evaluation. I would maybe say that, and this is one of the things we'll talk about in a few minutes, but I don't expect a team to write a goal without present levels. So I have run into some cases where even after an IEE, we have done some additional testing to gather appropriate and accurate present levels, because an IEE can happen. I had one happen this summer and we just had a meeting for it. So we needed to kind of know how the kid was doing now. I try to push teams forward in a productive way when that happens, because often the kid is waiting for services and like we need to get moving. And you know, there's an ETR, then there's an IEP, then there's an IEE, and we've got months happening. And in the meantime, we've got a kid who might not be getting what they need. So I think without knowing the specifics, that's kind of what I would maybe say the team might have been thinking, but you would have to sign consent for any evaluations. Does anybody else have a question about like what we've, okay.
Sort of building off that.
Okay.
So if a parent has an evaluation that they obtained on their own, that they already paid for, does the school team have to consider it? And practically, what does that look like for a parent?
Yes, the school team has to consider any data provided by the parent. Practically what that looks like in the ETR process would be that you would aim to share it with the school team ahead of that ETR meeting, ahead of that evaluation meeting. Because when you have that ETR meeting, you've got a school psychologist in a meeting, you've got a SLP in the meeting, maybe an OT, people who are qualified to interpret the results that are in the evaluation and in the outside evaluation. So practically during the ETR process, it would mean sharing it as soon as possible. It can absolutely mean bringing the outside evaluator to the meeting. Parents are allowed to bring in whomever they want that may have a relevant interest in the education of the child. So it could look like that. During the IEP process, you could share with them at any point, you know, hey, I think this reading data is super interesting for the goal we're trying to write. If you want to do further testing in this specific area, I would welcome that. But this is some data I have for you right now. Or if it's on and off time where you don't have an IEP, you don't have an ETR, you are legally allowed to call an IEP meeting once every 30 days in the state of Ohio. I don't recommend you do that if you can help it, because I want to be efficient with everybody's time, and some meetings absolutely can be an email. But if you have an outside evaluation to share and you think that it's relevant because your child has been through some change, or you have a new diagnosis, or like something isn't gelling and something isn't working, practically that's what I would do, is aim to share it with the team as soon as possible. Legally, the standard is meaningfully consider, which means that we must do more than say that we read it. We must do more than put it in the file. We must have a discussion, have a meaningful discussion, make sure everyone around the table understands what's in the report. Make sure the parent at the table understands how what's in the report can impact the student's ability to access their education. Any other questions for the first part? Oh, I'm going to talk for a long time. Oh, Leah's very happy about that. Okay. Okay, so dispute resolution, and then we'll briefly talk about stay put. Before I go into the dispute resolution part, I want to say, like, and I said this at the beginning, complaints are part of the system. It is complicated, and it's not going to function perfectly at all times. It is also unfortunately underfunded, and that is not the fault of our educators. There's a lot here, and sometimes we need a second, third, or fifth set of eyeballs. Complaints are part of the system, and I'm going to say that again. Invoking your rights should not trigger retaliation. I'm going to say that I have not personally seen a case of a district retaliating against a student for their parent raising the complaints. I do know that some people have experienced that, and I want to validate that. It is It's okay. It is, sorry, it's difficult, and okay. Sorry, I'm going to continue. So the options we have for dispute resolution, mediation, state complaints, and due process hearing. In Ohio, we have facilitation, which is when a state facilitator comes in and tries to help you move past your conflict. It's a step below mediation, and often the first thing that will get offered to you if you have a team that isn't working together well, they'll have a state facilitator come in and try to figure out where the disconnect is and move teams past usually one specific conflict. If this is like a big deal, I think I have experienced the state saying, facilitation might not be for you. But it's an option. It's a thing we have. It is a thing you can ask for at any time. Both parties involved must agree. So the school must also agree. I've not encountered a school not agreeing to facilitation. So that is a thing that is available to us, and it's not available in every state, which is kind of cool. Okay, so real quick about stay put, and then we'll talk about due process a little bit as we move forward, but I want to preface that by saying that due process as an advocate is not my area of expertise, because in the state of Ohio, advocates are not allowed to act on your behalf in a due process hearing. In other states, they can, but in the state of Ohio, no. You can represent yourself in a due process hearing. You can appear pro se, or you may hire an attorney. The process of and the cost of which I'll talk about a little bit later when there's somebody in the audience shaking their head right now, no. I will talk a little bit about later, but I will say I want to mention stay put because it's important, but as an advocate, due process is not something that I deal with on my day-to-day. I, in my professional life, prepare cases and work cases. I may have to hand them to an attorney someday, so I try to just keep really thorough records. And if something escalates to a due process, I want to be able to have helped save resources by getting it ready to hand to an attorney, but it would be something I would be handing off and not doing myself. The right of stay put is a right we have when something moves to a due process. When you have filed for a hearing, you can invoke your right to stay put, which means that the IEP that's in place, the placement that's in place, the services that are in place, they all freeze pending the hearing. So you must notify the district that you're invoking your right to stay put. You should notify the Department of Education that you're doing that as well. And basically what that means is through the duration of a due process hearing, nothing changes. Nothing changes about the IEP, services, placement, nothing moves. So if that's part of the dispute, then that is temporarily frozen in place. So that's our right to stay put.
And is that, do I have to affirmatively say I am invoking my right to stay put, or in filing for that hearing, in filing for the process, is that understood?
So the question is, must you affirmatively say, I invoke my right to stay put? Yes. Always just say yes. If whether or not it is part of the dispute, the placement, the IEP, whatever's happening, I say yes. You must, and I believe that you must notify the district that you are invoking your right to stay put. Yeah. Okay. Okay. So that's kind of the dispute options we have. That is an example of a violation of stay put specifically. And then I'm going to talk about some very common violations that we see for which we may want to file a state complaint if we cannot get teams to work together. I'm going to preface this by saying I am not a huge filer of state complaints. It is a tool. It is a tool I have used, but generally, I have had more success, A, through mediation, which is an option that's available to us in the state of Ohio, and B, through trying to bring teams together, and sometimes trying to bring teams together by saying, Our next step is a complaint. And that necessitates a lot of paperwork for everyone involved. And that is adding 60 days onto this timeline to wait for a decision. And that means we all have to participate in an investigation. And what can we do before that to bring everybody together? These are tools, and I believe in the tools, and I believe in the process, and that's why I do what I do. But I think that in most cases, parents are, and this is part of what I want to explain tonight, remedies in the state complaint process are corrective. They are not punitive. So all that we may do with a state complaint is remedy the procedural error. So if we have changed a placement without notifying parents, we must then notify parents. The answer is not pay for private school. The answer is we must remedy the procedural error. And I think that's frustrating to some parents, especially when we've gotten to the conflict place, right? Like, teams are broken down, feelings are running high, and we feel like the district is not hearing us, and the teachers aren't hearing us, and we're asking for things that are going unanswered. And I think that sometimes the state complaint process feels like it could solve that or settle that. And the reality of the situation is that it likely will just correct the errors. But it does bring in outside people to make sure that those errors are corrected. And oftentimes that can get us back on the right track to a better program, a better IEP, a better evaluation, and a team that functions. I think sometimes even teachers will tell you they don't know everything. I know that's shocking, but they don't give them a ton of special education training in basic, like, I have a friend who's an educator, and she said that she teaches middle school, which, yikes. She said that one of the things she wishes she had in school was more training in the IDEA and special education processes. If you're not going into special education, you often aren't given as much support in those areas. And so teachers don't know everything. They may not know that these procedural errors are happening. It may have not made it all the way up to admin that these procedural errors are happening. Like, we're all trying to put out our own fires and solve our own problems. So often the state complaint process can help us correct those errors and bring in outside eyeballs to do that if you feel that your team is not functioning enough to be able to correct that on their own. But as parents, I want to empower you. Like, if you know that a rule has been violated, please bring it to the school. Like, find the rule. I think somewhere in this presentation in the slides, I wrote where in the regulations each law lives, where the IDEA lives in the Code of Federal Regulations, and then where in Ohio law our special education laws are. They are organized by subject. I encourage you to please find the rule. They're not, yep, Sarah's on it right now. She's got it up. I encourage you to find the rule and bring it to the school. I'm not a lawyer. You do not have to be an attorney to read and know the law. It is, in fact, your responsibility as an American and your right as an American, and that's super cool that we get to do that. So if you are aware that one of these common violations that I'm about to go through is happening, find the rule and bring it to the school and start there. But know that if you draft a state complaint, you'll also need to know where that rule is. So get familiar with the laws that are governing your child's special education. Where are we? Okay, common violation, failure to implement the IEP as written. The IEP is a legally binding document. Services must be delivered as written. You would want to see in the IEP location, duration, frequency, where it's happening, when it starts, when it ends, what room it's happening in, which teacher it's happening with, what it looks like, what they're supposed to be doing. Data collection is a requirement. We need to see actual quantifiable data. I'm going to talk a little bit more about data in my upcoming slide on progress reports, but we need to see actual data. We need to see how a student is doing, and it needs to be presented to you in parent-friendly and understandable language. If they're like, oh, well, he got a 42 on the blah, blah, blah test. And you're like, I don't know what that means. Please slow everybody down. Please ask them to break it down for you. Please, where is he right now? Where do you expect him to be at the end of the year? How do we get him there? Those are really good meeting slowdown questions. Like, how do we get there? How do you expect to do that? I'm not a teacher, and I am not, this is going to be shocking news because of what I do for a living. I'm not particularly awesome with children. So I trust the teachers in the room, but I need them to explain it to me. They're the experts. They're the ones who study this. They're the ones who know this. They're the ones who know the processes. But I need them to explain it to me, and I need them to slow it down. And I ask those 3 questions. Where is he now? Where do you want him to be at the end of the year? How are we going to get him there? And this is like how we get at parent understandable data. So things we would look for: failure to implement the IEP, related services not delivered, accommodations ignored, lack of progress as expected. That last one, lack of progress as expected, if you're getting progress reports and your student is not making progress, and the team, again, how do we expect to get him there, right? And the team is saying, oh, he's doing okay. He's like not really doing it, not really making progress. There's a provision in the law called review, like I call it review and revise. If a student is not making expected progress, it is the team's responsibility to meet and review the data and potentially revise the IEP based on whether or not it's working. I do tell teams, give it some time, but give it time with good data. And we'll talk about what that looks like in a minute. But do give it some time, but these are things to look for in terms of not implementing the IEP as written. Okay, common violation, denial of parent participation. This is one thing we talked about earlier. You are the most important member of your child's team. You need to participate. I think I went over most of this before, so we won't spend too much time on this, but this is like my advocacy tip here. Write it down, send a summary, correct the record. I'm that girl. If we talk on the phone, I'm gonna send you an email afterwards. Hey, so-and-so, really nice to talk to you today. We talked about X, Y, and Z, and it is clunky and awkward, but it creates a record, and it creates something we can come back to if we have a dispute later. It creates our ability to continue the conversation if maybe we didn't get to finish it, and then it lets us all know that we're on the same page. Correct the record, that's one of the things I talked about earlier with the prior written notice. If you get that form and you feel like it doesn't reflect the totality of the discussion that you had in the meeting, and it doesn't give you good data about why the district is making the decisions it's making, ask that it be corrected, expanded, ask that it be edited. I will say oftentimes what I see districts do instead is they'll attach your email response as a PDF. That's fine. It's part of the record. I wouldn't get too caught up on whether or not the actual form gets edited. I try to pick my battles. Question is, have I seen anybody use the AI transcripts? I avoid AI because everything I do is super confidential. I have had parents sign on to Zoom that have the AI note takers. I believe in most cases they've been asked to shut them off. I did write in this slide, and one of the things I'll just talk about briefly is the ability to record a video in the state of Ohio. You are allowed to do so. We're a single party consent state, so you can make a recording of your meeting. I do not advise that you do that surreptitiously. I encourage transparency. If you're going to make a recording, let the district know that you're going to make a recording. Provide them advance notice that you're going to make a recording. They will do the same. It's standard practice, and it shouldn't scare anybody. I have a family who has a hearing disability that records all of their meetings just because that's something they need to be able to go back to it. If you do have multiple disputes over time and multiple back and forth about, the PRO one says this, and I think it should say this, I would consider recording your meetings, but again, consider recording them in a transparent way and giving the district notice. just letting them know that to avoid further disputes and to make sure that everything is on the record, you intend to record the meeting from this time forward. You will welcome the district making their own recording as well, and that's totally fine. But yeah, the AI, I'm kind of a... The transcript, yes, the comment is the transcript might be helpful, and it might be. In that case, I would probably just advise. I just can't think about giving a thing information about what goes on in that meeting. You know, like if I'm going to make a recording, I have possession of the recording, and I know that I do. And if the district is going to make a recording, they are obligated to keep that in the same way they keep all of our students' records. So I would feel safer with that than I would with the AI, I think. Okay, so that's that. Okay, common violation is a failure to evaluate. This law is called the child find law. Districts are required to find, locate, and evaluate any students who may be suspected of having a disability and may need special education and specially designed instruction and related services. Schools must identify and evaluate. I just said that. MTSS, RTI cannot be used to delay an evaluation. MTSS is a multi-tiered system of supports. RTI is response to intervention. So what that looks like is short-term intervention, which is used to close a gap. The goal of MTSS is to identify gaps and then aim to close them in a relatively short period, typically between 6 and 12 weeks. Anything beyond that or multiple cycles in MTSS for the same issue, we would want to write a request to the team and ask for a full evaluation in all suspected areas of disability. If you have reason to suspect that it is due to a disability, again, I am grateful for schools' ability to iterate. And MTSS is great, but it is meant to close short-term gaps. It's not meant to be a cure, and it doesn't ensure access, and it doesn't come with the legal protections that our students receive under the IDEA. So that is, it's schools' affirmative obligation, meaning it's something they have to do, and it's something they have to be proactive about, and they must evaluate. It does not mean they must qualify you for special education. It does not mean they must write you an IEP. It means they must evaluate. And it means we must evaluate comprehensively, which means in all areas of suspected disability and according to cultural requirements and in the way that would be most likely to yield the most accurate information about the child. So that's at the discretion of the psychologist or the people doing the testing, but in general, we would, those are our basic requirements. Did somebody,
Question.
Just real quick, will you go back, like what those acronyms mean again?
Yes, MTSS and RTI. Okay. Did I put them on the sheet? Oh, man. Okay. I'm going to write myself a note about that. MTSS means multi-tiered system of supports. RTI means response to intervention. Both of those things mean processes, like short-term processes of intervention that a school would use to close a gap. If somebody's reading a little bit behind, if somebody's, fall benchmark reading test says that they need a little bit of extra help to catch up. It can be behavioral. If somebody is having behavioral challenges or social challenges, a school can institute some short-term intervention to try to close the gap and catch them up to their peers. Yeah.
And for those, does the school have to tell you that they're doing that with your child?
No. I mean,
The question was, do
Thank you.
School districts have to notify you about providing RTI or MTSS?
so no, they don't. They do often, right? You'll get a phone call home that says, hey, little Johnny's not doing great in math. We're going to try this for 6 weeks, and we'll let you know how it goes. But no, they don't. And MTSS and RTI are not processes that come with disability protections. They're great. When schools do MTSS really well, you often see big improvement in data in short periods of time, and that's really cool, right? Like you can put a reading specialist on in a classroom for 6 weeks and see vast improvements, but they are not a substitute for a student who needs specially designed instruction in order to access the general education curriculum. Yes.
So MTSS includes like any type of assistance that a student might need, and it includes like a student has had strep throat, they've been out for a week. So like our concept and understanding of MTSS would provide some support to that student to recover from that absence, or out for a funeral, or some kind of short-term need. I can't say in all cases a parent would be like called to say, hey, I'm going to help your child, catch up on the work they missed when they had strep throat. I think there's some understanding there that that's needed and that would happen. But if it's a more formalized process in which the student would have an MTSS goal and there are professionals meeting to discuss the progress of that goal, parents will absolutely be notified that's happening.
Thank you, Amy. I was trying to catch your eyeballs when I was doing that. I was like doing this thing. It's okay. No, I appreciate that a lot. And parents would be notified. Should note that Dr. White works for Bexley City Schools. And so parents would be notified in Bexley. I have run into districts where they are not notified. And that is maybe a weakness in the MTSS process. And that's a whole different presentation. But what a school cannot say, to distill it down, is, well, he's an MTSS, so we're going to wait and see. We're going to wait and see if we need to evaluate him. If you have a sufficient reason to suspect a disability, then a school has an affirmative obligation to evaluate them in all suspected areas of disability. So to try to uncomplicate that a little bit, that's how I would describe that. They can't just say, we're going to wait and see how he responds to intervention. If you have a reason to suspect a disability, then we need to do an evaluation. Response to intervention is useful data, and it's part of the evaluation form in the state of Ohio. Like, you have to have it in there. So we do need to know what their response to intervention is as part of the evaluation process. But it cannot be, well, we're going to wait and see, and that can't be it. Okay, this is my favorite slide. So I'm going to say this. So this is a concern. I separate things into issues and concerns. And for me, this is like big concern. Does not always rise to the level of an issue being a thing we'd file a state complaint about, but this is the thing I want to talk about because I have an audience right now. So for me, everything in the IEP rests on the present levels. We used to call these PLOPs, present levels of performance. Now we call them the PLAFs, present levels of academic achievement and functional performance. I like PLOPs better. But basically what that means is that first question that I ask in an IEP meeting to slow everything down. Where is he right now? How is he doing right now, today? Present levels, academic achievement, reading, math, science, functional performance. That's social stuff, that's communication, that's potentially where like physical therapy would come in. What is their gross motor ability to access the environment around them? It's potentially where occupational therapy would come in. What is their, how is their planning and ability to put their body in space? And how does that help them or hinder them from accessing their education? Functional performance. We're not just talking about like, how is this kid doing in reading? And that being the meat of the IEP. It's how is this kid doing in everything? Where are our challenges? Where are our strengths? What do we need to do to close the gap or to make progress for the duration of the IEP? In students with disabilities, gaps won't always be closed. But what we're always aiming to do, since our students are general education students first and special education students second, is enable them to make progress in the general education curriculum and enable them to stay in school with their peers. Present levels should drive goals. If you can't clearly describe the starting point, you can't design an appropriate goal. This is not always like super cut and dried. it's not always a matter of we're reading at a 4th grade level, we want to be reading at a 5th grade level. Sometimes it's we are struggling to engage appropriately socially with peers on the playground. And then we think about what our instruction looks like to get them to the place we want to be, which is closer to their peers. I always encourage parents to read the Ohio State Learning Standards. I know that sounds like super entertaining reading, but it's really helpful. Go look at the standards. There are tables by grade level that tell you, what we expect students to be doing mid 6th grade, end of 6th grade, end of 9th grade, beginning of 1st grade, like where we want as a state, where we want our students to be and how we want them to be doing. Go look at the state standards. Use that as a guide. If you know you have a student who demonstrates needs in the area of math, go look at the math state standards for their grade band. Think about where they are now. Think about meeting those math state standards. Discuss with the team whether or not it's a realistic goal to do that within a year, and then talk about how we're gonna get there. And then talk about how we're gonna track the data, how we're going to know whether or not our student is making progress. Does it mean that does progress look like them doing their general education homework without assistance? Does progress look like them doing half the homework of their peers but being able to answer the questions correctly? Does it look like reading with the help of an audiobook? Does it look like using a graphic organizer for writing assignments? What does the graphic organizer look like? What are the expectations about the graphic organizer? Who has it? Where did they get it? Can it come home? Is it used for all assignments? Is it used for an English writing assignment and a science writing assignment? I know this sounds like I'm rambling a little bit right now, but these are super important questions. Again, for me, favorite slide. I feel like in meetings, we get really stuck on talking about and reading through the goals and objectives without really breaking down what it's going to look like to teach them and what it's going to look like for progress to be reported. So I like to live in the meetings in section 7 of the IEP, where the especially designed instruction is. Because for me, that's how we help parents understand how we're going to teach, right? How are we going to teach this child in a way that helps them get from point A, which we have clearly identified because we know how to do good present levels, and if we don't, we need to talk about it, to where we have decided they can realistically be at the end of the year. What does it look like in 6 months? Does it look like 4 math problems out of 10? Does it look like a grade level book that's shorter? Does it look like answering comprehension questions? Where does it look like? What does it look like in 6 months? What does it look like in a year? What does it look like if we are not making progress as expected? What should we expect to see on a progress report that comes home if we're not making progress as expected? And name that and talk about that in the meeting, because it helps districts when they are aware that you know the processes. I know that there are teachers who are like, oh man, this IEP goal is not going super well, but I haven't heard anything, so it's probably fine. They seem to be doing well in the rest of their goals. But let the team know that you know the processes, right? Like, okay, so if we get to 6 months and he's not doing X, or we're not quite at X point, or we have not made an improvement in 3 months, can we get back together and talk about whether or not this IEP is working? Can we expect to revise if it's not gelling for him? And how are we going to teach it? And what do we expect progress to look like? And I just realized what time it was, and now I'm going to start to talk a little faster. Anyway, this is my favorite slide. Question that I always say, like, we're going to reframe the conversation. Based on this data, is my child on track to meet the IEP goal by the end of the year? And again, how do you know? Explain it to me in a way I understand, but how do you know? Anyway, I could talk about that all night, as I'm sure everybody has figured out. Least restrictive environment, this is another one that is a kind of a common violation. Basically, the principle in the law is your student should be educated to the greatest extent possible with their general education peers. That means that they're in the gen ed classroom 100% of the time. That's the least restrictive environment. It goes all the way down the continuum of alternative placements into like home and hospital instruction, which happen in the case of serious illness or injury or a student who just, according to a physician, cannot be educated in the classroom. There are alternatives that, if we start here at 100% gen ed and go all the way down to home and hospital instruction, there are alternatives that fall along this continuum. Partial days, other schools, push-in services, pull-out services, parents of students with IEPs, we've heard all of these things. The reason I put this in here in common violations is that in the state of Ohio, we require a parent signature before we change placement of a student, and that is sometimes where I see a procedural violation, so just make sure that you're getting notified of a potential change in placement, that you are agreeing to it, and that you're getting a signature, and that you have that in your records so that we have data on when and why we moved a student and that it was a parent agreement. Okay, filing a state complaint. I've been talking too much. Okay, so again, I think I've talked about this during and throughout the whole presentation, but it's a guardrail, not a escalation. It is not declaring war. It is calling in expert eyeballs. You have to submit a written complaint to the Ohio Department of Education. It's the Office for Exceptional Children that handles these. There's a form on the website. It shows you all the information you need. It's pretty easy. In some states, they don't have that, and it's kind of frustrating. You must allege a violation of IDEA or state rules. Violations must be less than 1 year old. That's the difference between a state complaint and a due process. State complaint look back is 1 year. The due process look back is 2 years. So the violation must have happened less than a year ago. The OEC will investigate. That's when we talked about, this is a lot of paperwork. You will be required to submit all of your evidence. The district will be required to submit all of their evidence. They will interview both parties involved, and they will issue a decision. State complaint decisions are not appealable within the state complaint process. Once the decision comes down, that is the decision. If you disagree with that decision, you may move to due process from there. But state complaints are not appealable in and of themselves. They are not editable or changeable or at all movable. Once they happen, you're done. So be organized, submit all of your evidence, keep good documentation, be clear and concise in your interview, and know how to tie everything to the rule that you're alleging is violated. And then we talked about this earlier. Remedy under the IDEA in this process is corrective, not punitive. So they're going to make them fix the problem. There's no, go back and pay for my tutor. There's no, not through this process. That's something that, that's another discussion. But they will make them follow the letter of the law. So if that is an issue, if we are having procedural problems, and we can't agree on what the procedure is, a state complaint may be a good option. If you brought the rule to the school and you said, I'm alleging that this is a violation, and they're like, no, I read it this way, and you have evidence to the contrary, it may serve the team to bring in the state and have the state make them correct the violation. Okay, filing a state complaint. What makes a good complaint? Facts, not frustration. I think about that in all the things I do every day. I am often frustrated, but I try to stick to the facts. Something like the IEP requires something that's not happening. You have data to the contrary. You can submit that. That is a fact. Find the rule, cite the law or the regulation. And then impact, explain how the violation denied, FAPE, or blocked parent participation. Those are kind of the big ones. There does have to be and should be harm in order to necessitate doing so much paperwork. Something should have happened. There should have been a consequence, and you can explain it. This is where, there is a parent narrative, and you can put that in there. And there can be some feeling involved, but know that there's a lot of people that are going to have their eyeballs on this, so conduct yourselves accordingly. I've read some doozies. And then requested remedy. So figure out, under the rule, what it would look like to make them follow it. Fix the problem, correct the procedure, and then in some cases you will go back and have a claim to what's called compensatory education, which is we have to make up the services that we missed when the procedural error was happening. The ODE complaint form is linked here, and Leah has my slides, and I'm getting thumbs up. I feel so cool right now. Go down. Come on. Okay, real quick, state complaint versus due process. The state complaint is an escalation, but not necessarily as significant as a due process hearing. A due process is an administrative hearing. It's a trial. They call witnesses. There is a judge. It has a significant emotional and financial cost. I'm not here to discourage you from filing a due process hearing. I just want to be super clear, again, that this is not my area of expertise and that they can be quite intense. The districts will bring counsel. So if you do not have counsel, you're on your own. An advocate is not allowed to act on your behalf. You are allowed to consult with whomever. You are allowed to call expert witnesses. I have seen parents successfully represent themselves pro se in a due process hearing, but it is a very, very intense process. Then this just kind of gives you like the overview. This is the state complaint. This is the due process hearing. And then at the end I wrote, most families will begin with a state complaint before filing due process. And I think that actually the last thing I want to talk about, and then I will answer a couple questions and we can get out of here. But one of the things that's available to you as a dispute resolution tool that I didn't really talk too much on, and now that I'm going through this, I kind of want to say more, is mediation. Both parties must agree to mediate if there is a dispute. So the school will have to say, yes, I'm willing to negotiate, and you will have to say as a parent, yes, I'm willing to negotiate. But that is a process that is available to you through the Ohio Department of Education during a dispute. So you are free to file a complaint at any point. You do not have to withdraw your complaint in order to participate in mediation. There's a list of state mediators. It is a long meeting. Somebody, usually goes back and forth in a Zoom room between you and the district. So you have your team in this breakout room. School district has their team in this breakout room. Mediator goes back and forth, tries to help everybody settle the dispute. You are allowed to continue with your complaint after mediation. If mediation is unsuccessful, the mediator only changes anything about the state complaint if you notify them during the mediation that you intend to withdraw your complaint based on the results of mediation. These are the dispute processes that are available to you. Like I said, if you have a clear procedural error, I do think that if schools have reached an impasse and teams have reached an impasse and you just cannot agree on what the law says, I think that filing a complaint is a worthwhile exercise. I think that we need to call in an expert sometimes, and that's totally okay. A due process hearing, something that you can totally learn more about. The Department of Education, I actually just learned that the Department of Education is not currently publishing state complaint and hearing decisions, and they have not done so since 2023 due to some, I think, staffing issues. So there aren't super current complaints, but there is a searchable database of complaint decisions and due process decisions. So one of the things I always ask families before we go to the complaint process is, have you looked to see if somebody else has made this complaint? Those are publicly available things that you can use to bring to school teams and say, I know we're having this problem, but somebody else went to the Department of Education about this exact thing, and this is how this was decided. And so that is a resource that I always advocate that parents use, is that searchable database. And basically, these are the things that are available to you. I don't need that slide. Okay. I talk too much because that's what I do. We have a couple minutes. Does anyone have any burning questions? I feel like I have inundated everyone with information and it's dark outside now.
I'm going to go ahead and end the live stream. Thank you to everybody who joined. If you have specific questions for Lauren, her email is listed in the chat, and anybody who is registered for tonight's program, I have your email, so I'll send you all of that information. Thank you so much for joining, and if you want to turn the mic off, thank you again.